Janet Hui at JunHe LLP, currently stationed in Beijing. I'm specialized in competition law and M&A, and also currently served as the co-chair of International Bar Association's Antitrust section. As you may be aware, the First Amendment of the Anti-Monopoly Law came into effect on 1st August 2002, and this is a very important milestone in China because it strengthened the enforcement in antitrust regime and setting out some new principles on the antitrust law, and we need to be aware of about their implications. At the same time, the Supreme People's Court has issued quite a number of important decisions, which today I've selected 3 cases that I would like to share with you, and hope such principles will help you to understand how your business operation in China can compare with the legal requirements in antitrust regime in China. The first case that I would like to share with you is whether a party under cartel agreement can claim compensation against the other parties. Well, there are 5 kindergarten companies enter into a cooperation agreement, under which the kindergarten companies will share the income and expense together, and the profits will be distributed equally. At the same time, a kindergarten company, Company A, has agreed not to operate kindergartens in certain areas and will receive additional compensation. Unfortunately, the other kindergarten companies have defaulted in paying the compensation to the kindergarten company A, and that's why the kindergarten company A has filed legal proceedings to the court claiming for damages for the default compensation. The Court of First Instance has ruled that the 5 kindergarten companies have entered into a cartel agreement constituting price fixing and also market allocation. At the same time, they believe that this has restricted the competition in the market, and therefore the agreement should be invalid. The kindergarten company A was unhappy with the court's decision, and that's why they filed an appeal against that decision. The Supreme People's Court has reviewed the decision of the First Court of Incidence and believed that they have made a correct decision because the price fixing and also restricting kindergarten company A not to operate in certain market constituted market allocation, and the claim by compensation of the kindergarten company A actually is trying to gain more profit from the remaining kindergarten companies. Therefore, the Supreme People's Court dismissed the appeal and ruled that the agreement was invalid, and the parties under cartel agreement does not have right to claim compensation even if there's a breach of contract, because the agreement should be held invalid. The second case that I would like to share with you is about the clarification of the definition and scope of last fiscal year's revenue, which will normally be used by an antitrust agency for imposing fine against a company that is in violation of the anti-monopoly law. In this case, Company A, a fire safety company, has entered into a cartel agreement with other competitors under the organization of Hainan Control Association in 2018. In November 2020, the Antitrust Enforcement Agency of Hainan Province has conducted an investigation and concluded that such arrangement is illegal and imposed a fine based on the sales turnover of Company A in 2018 with 1% penalty imposed. Company A believed that the basis used for imposing the fine is incorrect, and that's why filed appeal against that decision in the First Court of Incidence. The Court of First Instance ruled that the decision made by the antitrust agency by using all the sales revenue of Company A to impose the fine is incorrect. The scope is too wide, and that's why it has dismissed the antitrust agency's penalty decision. The antitrust agency was not happy and appealed against that decision to the Supreme People's Court. This court decision is very important in two ways. The first is it confirms the scope of revenue to be used to impose fine will include all sales revenues of a company instead of limiting to the products or services involved. And this means that a huge amount of penalty may be imposed with that sort of a revenue basis taken into account. The second thing is that for any illegal behavior organized by trade associations, it would not be exempted. And that's why for the cartel agreement organized by the local agency, the Hainan Control Association would not be exempted from penalty and investigations. The last case that I would like to share with you is about the elements that will be determined as constituting other concerted actions under antitrust law in China. In 2016, 19 premixed concrete manufacturing companies in Guangdong province has communicated while meeting and WeChat to increase the price of concretes. Although there was no written agreement entered into by them, and the price increase for each company was different, they have increased the price concurrently. Therefore, in June 2020, the Antitrust Enforcement Agency in Guangdong Province has initiated investigation against the concrete manufacturing companies and concluded that the price increase, although the price increase was not the same, constitute a cartel agreement and imposed a fine against them. One of the concrete manufacturing companies was not happy about the decision and filed a claim at the Guangzhou IP Court, asked the court to dismiss the penalty decision. The Guangdong IP Court upheld the antitrust agency decision, and therefore the concrete manufacturing company appealed against the decision and filed that to the Supreme People's Court. The Supreme People's Court further explained that the conduct had anti-competitive effect based on the analysis of the structure, competitive situation, and dynamics in the relevant market. And there was no reasonable explanation provided by the concrete manufacturing companies. Therefore, the Supreme People's Court held that the conduct of the manufacturing companies constitute other concerted actions as stipulated under the anti-monopoly law, and the 19 manufacturing companies have implemented a cartel agreement. In fact, in this case, the 19 concrete manufacturing companies have exchanged competitively sensitive information, including the price increase, and also the timing of the price increase of the concrete. And at the same time, there has been an upward trend for the price increase concurrently at the same time. So those two elements will allow a presumption of cartel agreement. And unless they can provide reasonable explanation and also evidence to rebut that there was a cartel agreement, such kind of behavior will be deemed as a cartel, and the penalty decision issued by the Antitrust Enforcement Agency do have basis to do so. Therefore, we have always advised the companies that when the competitors they communicate in meetings or via WeChat, they should avoid exchange of competitively sensitive information, because this is very risky. Together with any consistent market behavior will be presumed to be a cartel agreement, and the Supreme People's Court's decision has reinforced that those two elements are very important in their assessing whether a cartel agreement will be formed, and if yes, an investigation and penalty decision would be upheld as valid. Those are the three cases that I would like to share with you, and I hope the takeaways of those three cases will assist you to know what are the legal principles that should be considered by the Antitrust Enforcement Agency and also the court, and will help you to make sure that the behavior of the company will comply with the legal requirements under the antitrust law in China. Thank you.